Hello and welcome to the third episode of the Wagner Students for Criminal Justice Reform podcast. I'm your host, Thurston Powers, and today we have Lauren Krisai, the Director of Criminal Justice Reform at the Reason Foundation. Welcome.
Hi, Thurston. Thanks for having me.
So let's start by getting to know a little bit about you. How long have you been working on criminal justice reform?
So I've been at Reason Foundation since 2013, and I've been working on criminal justice issues since, I guess, 2012. I briefly worked at the Cato Institute before coming over to Reason Foundation. So I've been working on these just for a few years, but yeah.
So I actually didn't know that you worked at Cato before. What was the path that led you to criminal justice reform here at Reason?
Well, in case listeners aren't aware, Reason Foundation and Cato Institute are both two libertarian think tanks. Cato Institute is probably like the libertarian think tank in DC. Reason Foundation is a libertarian think tank that also publishes Libertarian Magazine, Reason Magazine, and Reason TV. So I came to care about, criminal justice issues through my libertarianism, I would say, which for me started in high school. I was the insufferable, Ron Paul type of libertarian. I've always sort of stuck with this issue because to me, our criminal justice system serves, I think, as an example of just extreme government overreach in the worst possible way. The way that just the way the criminal justice system has manifested itself today, I think is just an example of government at its worst. But it's just something that strikes me as severely unjust, the way, these laws work and who we're locking up and for how long. There's so many different aspects of a criminal justice system that are in desperate need of reform that I felt compelled to get involved with this issue on the policy side of things to try to actually change these laws. So that's sort of what I'm doing in my role at Reason Foundation now. I direct a criminal justice reform program, and we do a lot of policy work on the ground at the state level. We primarily work with conservatives to try to get them on board with the idea of reform on a number of different issues, because there's so many that are in desperate need of reform, ranging from sentencing reform to bail reform in Connecticut, which I work with Thurston on, civil asset forfeiture reform, fines and fees in the criminal justice system in different states. So those are just some of the issues that I've worked on so far since I've been at Reason Foundation, and it's just been very fulfilling to me, and it's something that I would like to keep doing for as long as I can, just because this is an issue I think that I care deeply about, and I can't really live with myself to let these sort of injustices continue to happen and just sit idly by. So that's sort of how I came to it, but it started, I think, with libertarianism. So
yeah, so I find that I resonate a lot with a lot of what you said in terms of sort of like the individual rights and how sort of the expansion of state police powers has come at the expense of liberty. Mm-hmm. So now you mentioned that we work together in Connecticut. Have you worked in any other states on bail reform?
No, Connecticut is the first state that I've published anything on bail reform. Simply because I think the different issues that exist in different states, they vary greatly. Mm-hmm. And while, Florida has sort of a lot of heavy lifting that still needs to be done, and they're at the stage right now where they're examining their sentencing laws. They have harsh, sentencing laws for illegally possessing some prescription painkillers. Like, they still have mandatory minimum sentences for that, harsh ones at that. Wow. So that's the issue I've chosen to work on in Florida. But, in Connecticut, you guys are a lot further ahead on these types of issues than in the states that I've traditionally worked on. So bail reform is just another piece of the puzzle that needs to be addressed. And I'm happy to have done it in Connecticut, but a lot of states, they're simply not there yet, just because, I mean, if they're still sentencing people to decades in prison for, selling a few prescription painkillers, bail reform is not really high on their to-do list at the moment. So, but those are just, the states that I've worked in have just been, a little bit more problematic on a number of different issues, which is why Connecticut is the only one that we've really pushed bail reform on. And plus we had good conservative partners who were willing to get on board with that issue, the Yankee Institute there. So it just seemed like a good fit.
So now you mainly work with conservatives like the Yankee Institute, but on bail reform, who tend to be your allies, or really more broadly in general in criminal justice reform across different states, who tend to be sort of your natural allies when trying to form coalitions?
Well, I mean, this is criminal justice reform. I know if people have been listening to this podcast, and they likely already know that criminal justice reform is one of the few sort of bipartisan issues that, exist across state lines and at the federal level, although things are sort of up in the air at the federal level at the moment. It, at least in theory, is a bipartisan issue. Now, people come to this issue for different reasons. It appeals to conservatives for reasons that it might not appeal to liberals, and vice versa. But as libertarians, we play sort of a unique role because we can kind of bridge the divide there. We're perceived as more liberal on social issues, and we're more conservative on fiscal issues. So we find allies on this issue on both sides of the spectrum. Strategically, we've tried to build partnerships with conservatives over liberals on this issue, just because at the state level, if you want anything done on criminal justice reform, it has to come with conservative support. And that isn't to discount the efforts and the work that liberals have done on this issue over the years. It's just the reality of the situation is, if you want to pass something in Florida or Louisiana or something like that, or Mississippi, you need conservatives on board with that issue. It's not going to happen just by having liberals on board. So in those states, we think that it's more strategic to partner with the conservatives, get them on board with this issue, and push something through the legislature in that way, instead of partnering with just liberals on this issue. But generally speaking, it's a pretty bipartisan issue, all different areas of criminal justice issues. So yeah, it's an exciting time, and we have a lot of partners on the ground when it comes to pushing for this stuff. But we tend to just work with conservatives on this issue, and liberals where it makes sense. Like in Connecticut, we worked with the ACLU of Connecticut last year because it makes sense to work with the ACLU in Connecticut, obviously. So it just depends on what state you're engaged in.
So what sort of arguments do you find are most successful when getting sort of these Republicans who may have lived through the 1980s and are very, entrenched with the sort of hard on crime mentality?
Well, I think it's important to try to figure out, where those concerns came from. I think it's important to try to understand and be empathetic towards them when it comes to discussing the issue of reform. Like, conservatives didn't necessarily put forward these tough on crime laws just to be malicious towards, minority populations. I think they genuinely believed, well, they saw that there was a spike in crime in the early to mid 90s. And their reaction was, well, if we make our criminal laws tougher, we'll see crime decrease. And I think that understanding sort of what the origins of these laws actually was, instead of just seeing the problems that they cause, it helps you frame the reform message a little bit better. So when speaking to conservatives, people who are tough on crime, arguments that resonate with them are, yes, we understand why these laws were passed. It was because you saw that there was a spike in crime, and you thought that, making tougher, criminal sanctions would have decreased crime. However, the effect of these laws hasn't actually been what was intended. And if you show them all these different statistics that show, like, look, actually you're not locking up the kingpins, the drug kingpins, you're locking up a lot of first, second time, low-level drug offenders for long periods of time. These harsh mandatory minimum penalties are being applied to people outside of the scope of who you intended them to apply to. The prison population has exploded, and there's a lot of nonviolent felony offenders that are in there when you intended to lock up just violent offenders. I think they see that, okay, well, you know, maybe we need to try a different approach. And indeed, in a number of different conservative states, they have tried a different approach because those are the type of messages that resonate with conservatives. Like it or not, I mean, you know, I come to this from a different perspective, and I think that these laws that were passed, I think it was pretty clear that they weren't going to work from the time that they actually passed them. And I'm not like saying that I supported the idea of passing these types of laws, but it's just the reality of the situation is if you actually want to enact change and you want to speak to these types of people who have control over whether or not reform is going to happen, those are the types of messages that you need to be putting out there. So those are the types of messages I think that resonate with conservatives, is when you understand where they're coming from and you also show them that these laws didn't actually have the type of, or didn't produce the type of results they were looking for, and, you know, are expensive, ineffective. They're locking up people who shouldn't be locked up. I think they listen and they're willing to re-examine these laws going forward.
So what are some of the hardest to deal with counter arguments you run into with that message?
With criminal justice reform, or, I mean, it really just depends on who you're talking to in the state that you're working in. But some people just don't want to listen to your message no matter what you say. You know, a lot of people think that it just depends. I mean, the types of legislators, if they're in a certain position, they might not necessarily want to change any of the sentencing laws because they're like, well, crime did go down in the 90s. And, you know, that's one argument that I hear a lot. And it's important to recognize that, yes, you know, crime did decrease in the 90s, and probably putting more people in prison contributed. The most convincing argument that I've seen is that it probably contributed to like a 10% decrease in the violent crime was the prison population. So there's something to that, but it's not the only reason why crime decreased. If anybody tells you that they understand why crime increases or decreases and it's just this one factor, they're absolutely lying. It's something that people have been trying to figure out for decades, and likely never will. You're never really going to be able to point to why crime increases or decreases with 100% certainty. So that's sort of pushback that I've heard, is just, well, crime did decrease, and so I don't really think there's anything wrong with the way things work. You know, and some people just don't want to be responsible for if they make any changes to the laws and somebody gets out and they commit a horrific violent crime. Like, they don't want that blood on their hands. So they're just like, I don't want to change anything because I just don't want that to happen. I mean, that's another argument that I hear a lot. But they're not really sound arguments, right? Like, they're not very convincing or anything like that. So I think for the most part, you know, explaining to conservatives why these laws need to change, they sort of get it. And, you know, there have been sweeping reforms that have happened in states like Texas and Georgia and Mississippi. So, you know, and it resonates, and these legislators are willing to act. And so there hasn't been a whole lot of pushback on this, at least, you know, with any real arguments.
Well, one argument I hear about the sort of pretrial system that would replace cash bail or come in alongside it, depending on what system you're talking about, is that it adds cost. And a lot of states right now are struggling with budget issues.
Mm-hmm.
So does it?
Well, if we're just strictly talking about bail and pretrial services, you know, there's no state that has done away with commercial cash bail and only relies on pretrial services, as in, you know, monitoring of defendants before trial. There are some states that have sort of a hybrid of the two. A number of states, I think, like Illinois and Kentucky, they've done away with commercial cash bail, but they still have a bail system for defendants, but they pay the state instead. So they'll pay like 10% of their bail to the state, and then they'll get the full 10% back if they show up to court, or depending on the outcome of their case. There are some states like, well, the DC, they have a pretrial services agency that monitors, it does conducts interviews with different defendants and decides whether or not they should be detained or released on their own recognizance, or if there should be some monitoring. And that, of course, when you create like a pretrial services agency or something like that, you have to staff it. There have to be people that come with that. And it's going to cost money. But the alternative is, if you're sending fewer people, or if you're reforming the system in a way that results in fewer people being housed pre-trial in a jail facility because they can't afford to post bail, I mean, there's a lot of savings that come from that. So any sort of pre-trial alternative to, the bail system, which actually results in taxpayers having to pay for a number of different people who are housed in jail simply because they can't afford to pay bail. I mean, there are savings that are to be made there. If you can measure them, I mean, I haven't seen any statistics anywhere that have shown the cost savings of doing that, just because that type of model doesn't necessarily exist. So it's difficult to know. But there are certain things, I mean, even as a libertarian, there are certain things that the government should do, right? And so it's like, I'm not going to get all worked up about government spending money on a pretrial services agency, because I think that that's sort of the role of the government. So I'm not getting upset that the courts exist because taxpayers have to pay for them. I mean, there are certain responsibilities that a government has to fulfill, and I think this is one of them. So to get upset about this and to say like, oh, it might cost money to have sort of a pretrial sort of agency that instead of commercial cash bail, and there's alternatives there, it's really a drop in the bucket compared to, what government spends on other things, and it's not really worth, I think, getting upset about from a fiscal perspective, conservative, libertarian perspective, just because we don't know how much it will cost, and there's definitely going to be cost savings from sending fewer people to jail because they can't afford to post bail. So, yeah. Sorry if that didn't really answer the question, but
no. It definitely is an important thing to consider, because I know in Connecticut we spend about $120 per night per person to house them pre-trial. But in conversations, I've also learned that might be a significant underestimate because of a lot of the initial processing that goes into sort of booking someone and monitoring them when they first arrive. Like when you need to detox someone, for example.
Yeah.
Now, a lot of so DC was impacted by the sort of federal bail reform. How does bail work on the federal level now? Because I noticed that they don't have very much of a pretrial population.
Yeah, so the federal system, they started to, so the Congress addressed this issue, started to address bail, I guess, back in the 60s. So they passed the Federal Bail Reform Act of 1966, and it was the first major reform of the federal bail system since, I think, like 1700s or something like that. And it, contained the following provisions, like presumption in favor of releasing non-capital defendants on their own recognizance. So anybody who wasn't charged with a capital offense should be released on their own recognizance. It created conditions of pretrial release, with conditions imposed to reduce the risk of failure to appear for their court date. And it placed restrictions on money bail bonds. They could only impose non-financial release options if they weren't enough to assure a defendant's appearance. And they created like a bail bond option, allowing defendants to post a 10% deposit of money bail bond. So that was something that took place in 1966. In 1968, they passed another Bail Reform Act, which it added standards, to the 1966 Bail Reform Act related to the potential danger to the community as a factor that should be considered in making decisions. And they abolished certi bail for profit as an option. So they got rid of commercial cash bail at the federal level in 1968, which a lot of people don't realize that happened so early. And then in 1984, they passed the Bail Reform Act again, which was a part of the Crime Control Act, the 1984 Crime Control Act. And it mandated that pretrial release of a person on personal recognizance or upon execution of an unsecured appearance bond in the amount specified by the court, unless judicial officer determines that such release will not reasonably assure the appearance of the person as required or will endanger the safety of any other person in the community. They allowed for most defendants to be released on their own recognizance unless they found that, allowing them to do that would not assure the appearance of the person required or would pose a public safety threat. So that's sort of how it works at the federal level, is that most people are released on their own recognizance. And if they're found to pose a reasonable threat to not showing up for their court dates, then they'll house them pretrial. How they make those determinations, like whether or not they use a risk assessment tool, whether or not these determinations are largely arbitrary or not, is something that I'm not sure of. I don't really know how it works in practicality. I know that they have sort of a high pretrial detention rate of federal defendants. I don't know if it's because these are high-risk individuals or if they're not really very effective in the way that they go about this. But that's sort of how it works at the federal level, for better, for worse. And there's a lot of history there that sort of created the system that exists. So sorry to give a sort of long, tedious, boring history lesson, but I think it's important to know that these changes happened in the 60s and the 80s and, are still around today. So
yeah, no, it's all good. Very good to have historical context about these issues.
Yeah.
So now the federal pretrial system, though, that has a cost per person of about like $7, right?
Yeah. So there was one report that came out that said people who are monitored pretrial, so not necessarily released on their own recognizance, but have some sort of check-in that they have to do, or they have to be monitored before their trial. That costs about $7 per day at the federal level to do that, which is a lot cheaper than, of course, like detaining someone in prison or jail.
So now DC has been sort of spotlighted by like things like the John Oliver show. Its name is actually escaping me right now. But do they have similar sort of costs of operation?
I don't know a specific dollar amount for the DC system, but DC is very similar to the federal system in that like DC falls under federal law. So all of these different bail reform acts that were passed, DC also had to comply with, but they have something slightly different. So they created a pretrial detention or a pretrial services agency in the 90s. And they sort of tweaked the law a little bit there. So they have a much more like, they have a very well-established pretrial services type of scenario going on. So they do a lot of interviews. So every time that someone is arrested, pretrial services agency, like someone will interview that person and find out what risk they pose of either missing their court date or reoffending or, being arrested again. And they make recommendations as to whether or not this person should be released on their own recognizance, if they should be released with certain conditions, or if they should be detained until trial, which is, the courts have to find that there's a reason for detaining them. So due process is involved. I know that that's sort of how it works in DC. They have a very engaged pretrial agency. But I do not know what the cost is per person per day for them to monitor someone. I don't have that offhand.
Does it work? Do they show up for court?
So the way it works in DC, I mean, from the Pretrial Services Agency website, they found, like, in fiscal year 2015 that 91% of released defendants remained arrest-free while their cases were being adjudicated, and 98% were not rearrested on a crime of violence while they were in the community pending trial. So that's pretty successful to me. And they also found that 90% of released defendants made all scheduled court appearances. So that's a pretty good track record as well. And 88% of released defendants remained on release at the conclusion of their pretrial status without pending request for removal or revocation due to noncompliance. So those are pretty solid statistics. If only 10% have been, either rearrested and only 2% were rearrested for a crime of violence, I think that's a pretty successful pretrial system there. So
yeah, sounds like their assessment tool is definitely working.
Yeah.
So now I know that about like 1 in 10 people arrested in DC are denied pretrial release. They're held in pretrial detention. Now, some of that, of course, is due to the fact that DC has high rates of sort of violent crime. But I've encountered this argument that basically people have a constitutional right to bail. So how do you argue against that? Is there an argument?
Yeah, I mean, so preventative detention happens through due process. Like, it doesn't just happen where somebody says, okay, you're going to stay in jail until your trial. That the existing practice of setting high dollar amounts. So you're arrested for, a violent crime, a heinous violent crime, and your bail is $1 million or $2 million, $10 million. Like, the practice of setting a high dollar bond and hoping the defendant cannot make that bond, it violates due process. There's no process that an individual goes through in order to, like, they're just detained no matter what. Like, there's no due process because they can't afford to pay. But preventative detention, at least how it should work and how it works in DC, is that there's a hearing and, the court presents an indictment or a showing of probable cause in the charged offense that the government proves by clear and convincing evidence that no condition or combined of conditions of release will reasonably ensure the defendant's appearance in court or protect the safety of the community. And so these hearings that happen, that's due process right there. So it's not like somebody is just held in jail because some person says that they deserve to be there because they're accused of a violent act. I mean, there is a hearing that needs to take place in order to justify somebody's preventative detention. And that's a much better system than one that just sets high bail amounts that nobody can afford to pay, and they're just by default detained without a hearing.
Mm-hmm. So I was going to ask next about people's Fourth Amendment right and their right to privacy with these sort of drug tests and electric monitoring. but does the due process argument apply there as well to
I
like
mean,
conditions of release?
I don't know. That's a tough one for me as a libertarian. I mean, I have sort of trouble coming to grips with any sort of drug testing or anything like that as a condition of release before somebody has been convicted. And I don't really think that that's sort of an ideal system. It's
Mhm.
not something that I would be advocating for. I think that an effective pretrial system that monitors medium risk defendants. So I think it's important to classify where defendants sort of are. There's low risk defendants, which consist of the majority of those who are arrested. I think 66% or something of most arrestees are low risk of either being arrested again or for missing their court dates. So these people can be released on their own recognizance, which means there are no conditions attached to their release. And then the other people who are arrested, they might be medium risk of either being arrested again or skipping their court date. And that's either because, they have a long rap sheet, or there's a number of different factors that go into determining whether or not what someone's risk is. And most of them are objective factors, at least in the risk assessment tools that are effective. There are objective factors like, what is your criminal history? Have you ever missed court before? What are your community ties? Things like that. If someone is medium risk, like they may or may not show up for their court date, or they may or may not be arrested again, then, there are other effective alternatives to monitoring them in the community, alternatives to, just setting a bail, and if they can make it, great, they're out and there's no conditions. Or if they can't make it, oh well, they're just stuck in jail until their trial date or until they plead guilty. There are alternatives, I think, that are effective for those individuals. And that could be just checking in with a pretrial agent, be required to call in once a week, just update on, just random job check-ins. If the sort of how parole and probation works, just random check-ins with your probation officer, your parole officer. The pretrial service agent might show up at your job and make sure that you're there, or might randomly knock at your apartment. If there's a condition of your release as a curfew or something like that, they'll knock on your door and make sure that you're there. I mean, I don't think that drug testing should even be a part of that conversation, just because this person may have been arrested for a drug crime or something like that, but they haven't been convicted yet. So to subject them to drug testing before they've actually been convicted, I think is a problem. Whether or not that violates due process, I mean, I don't know. Personally, I'm not a lawyer, so I don't know what sort of legal implications that could have. But as a libertarian and just looking at this from a philosophical sort of perspective, I don't think that drug testing it should ever be a condition of someone's release from jail before they've been convicted of a crime. Now, all these other sort of monitoring conditions, I don't think violate due process, because that's just, I think the way the system currently works, it does violate one's due process, because if you can't afford to post bail and you're just stuck in jail, then what kind of due process are you getting? And I think that, when we're talking about this issue, there's not going to be a perfect outcome that everybody will be happy with. But I think it's important to remember that, some people they may pose a threat to the community, or they may skip their court date and then, not be held accountable for the crimes they may or may not have committed. And I think that, monitoring them in the community before their trial is a whole lot better than just housing them in jail because they can't afford to post bail, or allowing them back into the community with no conditions because they can't afford to post bail and they may pose a danger to society. So, as far as like whether or not some of these monitoring these defendants violates Fourth Amendment rights, I don't really know. I think that monitoring does not, but subjecting them to random drug tests and things like that could potentially. And I don't think it's actually effective in ensuring that somebody shows up to court anyway. So
Yeah.
But I should say, if it's shown to, guarantee that someone will show up to court, then, I mean, it's worth trying. I think that communities should experiment with different sort of the way that they monitor these types of defendants. But to me, I really don't think that it will show to have any impact whatsoever on ensuring that someone shows up on their court dates by subjecting them to random drug searches. I mean, I don't think it makes a whole lot of sense from that perspective either.
New Jersey it seems, is going to try something similar to DC. They're transitioning to a pretrial system in 2017. What does that system look like, and do you think it'll be successful?
Well, I think that New Jersey passed a great reform. And basically, essentially just, it came in two parts. So I guess it's worth explaining what actually happened there before I say whether or not it will be great. So the legislation in two parts. The first part implemented sort of, it was pretty wide-ranging reforms, which was kind of astounding that it even passed. But so they got rid of monetary release options for low-risk individuals. So anybody who's classified as a low-risk individual for, being arrested again or for skipping their trial date, they just got rid of the monetary requirements like cash bail for them. They also created a system which pretrial release decisions are based on risk rather than resources. So they created, they're creating a system that requires a risk assessment tool to be used to determine whether or not someone is low risk, medium risk, or high risk of either being arrested or skipping their court date, instead of just the current system, which required them to, it was a commercial cash bail system. And then they used a risk assessment tool for suspects, enabling courts to make individualized determinations of what conditions of release are appropriate. And then they are establishing a pretrial services unit within the court system, which will provide appropriate levels of monitoring and counseling for those awaiting trial. And finally, it protects the rights of those denied bail by requiring prosecutors to prove the case for pretrial detention with clear and convincing evidence. So sort of like the hearing that I was talking about before. Mm-hmm. And mandating clear timelines for speedy trial. And then the second part, so that's the first part of the legislation. The second part it came in the form of a ballot initiative, and which was passed by voters, which protects the rights of those denied bail. Or I'm sorry, I'm reading the wrong thing. It's an amendment to the state constitution, which allows judges to hold the most dangerous defendants without bail, discretion that federal judges, as well as judges in many other states, already have. So they needed to pass a constitutional amendment to allow that to take place, because they had a constitutional right to bail there. So that's what happened in New Jersey. Whether or not it will be successful, I mean, it's only time will tell. I think that in other states that have utilized a risk assessment tool, like in Kentucky, they haven't done away with their cash bail system. They've done away with commercial cash bail, so there aren't any bail bond agents there. Instead, the judge will set a bail amount and you pay 10% of that amount to the state. And then when you show up for court, you get that money back, all of it back. Whereas with a bail bond agents, you don't get that 10% back. In states, so Kentucky actually recently enacted you started utilizing a risk assessment tool that was developed and created by the Arnold Foundation. And since that time, their pretrial population has decreased by, I think, 15%. And their violent crime rate, which may or may not be correlated or connected to the pretrial population, has also reduced by 15%. So, I mean, it's shown, in states that have utilized a risk assessment tool in making bail determinations, which is what New Jersey will be doing, although they've done away with commercial cash bail, is effective. It has worked, and it's saved money. Now, I mean, of course, we just have to sort of wait and see what will happen in New Jersey, but in other places that have this, it has saved money and and reduced crime as well. So,
Do you think that there's going to be any states that follow New Jersey, or do you think that they're also going to sort of wait and see how this pans out on a state level?
I mean, people are also waiting to see how this pans out, but I think that, I mean, we've started to see a lot of movement on this issue. Already, I think the Pretrial Justice Institute, they have a map that they show at different conferences and things like that, which shows movement that's happening in different states on bail reform, whether or not it's something small, like just creating a risk assessment tool to make bail determinations, or if it's something bigger. It's happening in the majority of states. It's actually easier to count the states that don't have something going on than the states that do. So, you know, and recently, as far, like this last, on November 8th, you know, voters in New Mexico recently, overwhelmingly, voted in favor of a constitutional amendment that changes the way that their bail system works. So, and, you know, in 2011, former Attorney General Eric Holder, he's spoken on this issue many times in 2011, he was talking about, you know, many individuals who are housed in jail, they're charged with crimes ranging from petty theft to public drug use, and a disproportionate number of them are poor, and they're forced to remain in custody for an average of 2 weeks and at a considerable expense to taxpayers because they simply cannot afford to post the bail required, very often just a few $100s to return home until their day in court arrives. I mean, if this is a former Attorney General was speaking on this issue when he was Attorney General in 2011, I mean, this is an issue that people are paying attention to. There's been movement on the ground. I think the sort of like comprehensive reform that New Jersey enacted, that's going to be a little bit slower in a number of states. But as you and I know, like Connecticut is starting to look at this issue as well. Yeah. So that's another state that's sort of, you know, they're looking to see what happens in New Jersey, but at the same time, they're already moving on this issue separately just because it's an issue of that's just so fundamentally unfair, the way that its system works. And I think a lot of people recognize that. Like, people shouldn't be housed in jail who are charged with offenses, shouldn't be housed in jail simply because they cannot afford to pay bail. And especially individuals who are charged with offenses that, if they were convicted, wouldn't actually spend a day in jail. Like misdemeanor offenses, for example, misdemeanor prostitution and things like that in Connecticut. There are people who are housed in jail because they can't post bail for being charged for those offenses. But if they were convicted of them, they wouldn't actually spend a day in jail. So recognizing that this is how the system currently operates, it's broken. There are things that we need to do to be more effective in the way we monitor pretrial defendants, I think is something that a lot of people are starting to recognize, and it's not just a fringe issue anymore.
Well, hopefully we will continue to see movement. Do you think, so some people are concerned that the new sort of administration is going to change the direction of criminal justice reform. But other people are arguing that now that we have a lame duck Congress, we might see people actually pass some of these federal sentencing reform proposals that have sort of come up over the past year. Where do you think that criminal justice reform is headed in the next year?
Well, it's not going anywhere at the federal level, I hate to say. I don't really see anything happening on this during the lame duck session. I doubt anything will be passed. And even the current, like the two most popular bills are the ones that have gotten a lot of attention aren't even all that great because they do, I mean, while they do significantly reduce some mandatory minimum sentences for drug offenses and, you know, do a wide range of other things, they create new mandatory minimums as well. So, you know, I'm not a huge fan. But also, I don't think anything's going to happen at all. The real reform is and always will be happening at the state level. You know, like I don't really see that model changing anytime soon, which is great. So federal level, no, nothing's happening. State level, yes, that's where everything is happening, and that's where we're going to continue to focus our efforts. So. I don't mean to be pessimistic. That's just me being
No,
realistic.
I mean, I don't have very much hope for the federal government myself. So
yeah.
Well, thank you so much for joining us.
Well, thanks for having me. was great.
And thank you to the audience for hearing us out. And if you enjoyed it, please subscribe. See you later.